Welcome to HeadLocke, the official podcast of the John Locke Foundation. I'm Mitch Kokai. As the U.S. Supreme Court prepares to head back to work, we're looking back at key rulings and trends from the High Court's last term, and we're getting help from Ilya Shapiro. He's director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute. He's publisher of the Cato Supreme Court Review, and he's author of the new book, Supreme Disorder: Judicial Nominations and the Politics of America's Highest Court. More on the new book in just a little bit, but first we're going to talk about the last term of the Supreme Court. Ilya, welcome to the HeadLocke podcast.
Good to be back. Sorry we can't do this in person, but such are the times.
That's right. Well, first of all, we're going to talk about key rulings. As you look back at what happened during this last term of the Supreme Court, what stood out most to you?
Well, first of all, this is the year it really became the Roberts Court. Chief Justice John Roberts presided over Donald Trump's impeachment trial. Remember that? That seems like a different world. And then he navigated the court through an unusual pandemic-driven telephonic oral argument, complete with toilet flushes and people forgetting to take themselves off mute, and showing how the justices are just like us in many respects. And Roberts was in the majority more than anyone, including 12 of the 13 5-4 decisions. So he's really driving the court, not necessarily as a swing vote, but kind of an anchor or a driver of where the court will go as far and as fast as only he wants. The first case I want to mention is what we thought was going to be the first Second Amendment decision in over a decade. New York State Rifle and Pistol Association versus New York. New York City had an unusual rule that said you can't take your lawfully licensed firearms outside the city for any reason. The city defended its rule through appeal to the Second Circuit, but once it got to the Supreme Court, they kind of chickened out and, seeing the writing on the wall, repealed the rule, and then the state legislature said that no municipality can have such a rule. So it became a mootness question, and in the end, by a 6-3 vote, the court did rule that this was a moot case, although Justice Kavanaugh, writing in concurrence, said, look, we have all of these good petitions coming up, so I agree with the dissent that the court needs to address the issue soon and along the framework that the dissent suggests. Well, a couple of months later, the court denied all 10 pending cert petitions, raising the Second Amendment in a whole host of ways, whether the right to carry concealed or open, restrictions on magazine capacity, lots of different things the court could have chosen, but turned them all down, presumably because John Roberts told his colleagues that he was not a reliable vote on this issue, didn't want to take it up. And the same day, the court denied a slew of qualified immunity cert petitions, the idea that government officials, it's very hard to hold them liable, whether we're talking about police, educational administrators, any kind of government officials. Holding them liable is very difficult because of this doctrine. Notably, Justice Thomas dissented both from the denial of the Second Amendment cases and the qualified immunity cases. And Mitch, it was a big day because the same day that those denials were issued, the court decided Bostock versus Clayton County, the big employment discrimination case, where Justice Gorsuch, writing for the majority, found that Title VII of the Civil Rights Act of 1964, which prohibited discrimination because of sex, already included protections on having an adverse employment action taken for sexual orientation or gender identity. This was a battle of textualists, and ultimately, I think Justice Kavanaugh in dissent probably had the better of it, saying, look, forget even trying to get into the minds of Congress in 1964 or what the words because of sex meant in 1964. Even now, even in 2020, if someone's fired for being gay, we don't say that they're fired because of sex. So Gorsuch's take was kind of hyper-literalist in a way that speakers of the English language generally wouldn't use it. And there was a lot of concern after this decision and a lot of renting of garments, particularly among conservatives, about whether Gorsuch has shifted to the left or what this means for religious liberty. And it turns out Gorsuch, in a trio of cases on religious liberty, ended up the most protective of it. Most notably, there was a case called Espinoza versus Montana Department of Revenue, which by a 5-4 vote removed what I consider to be the last federal legal obstacle to the expansion of school choice programs. Now, as you know, in North Carolina, there are all sorts of state challenges on state statutes, state constitution, and what have you. But as a matter of federal constitutional law, Espinoza means that the Constitution is no obstacle.
Yeah. So as you are recounting some of these big cases, were there particular trends that you saw? You mentioned one of them, this now becoming the Roberts Court in many respects. Other trends that really stuck out to you?
Yeah, I mean, it was a term that was hard to characterize. I mean, every year, reporters, pundits try to say, "Oh, the court moved left," or "Oh, the court moved right." But it's not like over the summer the justices take a vote and decide, or even each individual justice decides, okay, this year I'm going to be more liberal or more progressive or more conservative or what have you. It's just a nature of the kind of docket it is. And those high-profile cases, I didn't mention also Daca, where the court voted 5-4, another John Roberts opinion preventing President Trump from rescinding Daca, even though President Obama put it in as a simple executive action. Also on abortion, the June medical case, where John Roberts again said, I disagree with a precedent from 4 years ago, but I'm going to hold to it, and only on those lines prevent Louisiana from putting in a regulation that threatened to shut down some abortion clinics. But at the end of the day, when you go beyond those kind of very, very high-profile culture war cases, and you look at the numbers, of the 13 5-4 decisions, 9 of them had the conservative justices sticking together, and only 3 had one of the conservatives defect to join the progressives. Compare that to the previous term, one of the 20 5-4 cases, 8 of them had one of the conservatives defect to join the liberals, and only 7 had the conservatives stick together. So this is why progressives surely breathe a sigh of relief, but aren't treating Roberts as the second coming of Anthony Kennedy, let alone David Souter. But again, I had a piece in the Washington Examiner in July called Roberts Rules, trying to dissect this strategic thinking, or as he considers to be strategic thinking, to counterbalance the political branches. And I think should Joe Biden win this presidential election this fall, we'll probably see John Roberts vote in a more conservative direction. Now, I don't think this is necessarily a good thing that he's voting not necessarily on his legal theories or his vision of the Constitution or statutory interpretation, but that's the way that he sees his role as kind of a protector of the institution of the Supreme Court. And anybody can judge the court's so-called legitimacy or the public confidence in it, but these kind of machinations, to my mind, detract from the court being seen as a legal institution.
Now that we've had more time to see Neil Gorsuch and Brett Kavanaugh on the bench, what is your sense of their approach, and does it really stack up with what we expected out of them?
I think so. I mean, they're both definitely originalists and textualists. In fact, as I mentioned, that Bostock employment discrimination case, it's not like, one side was arguing about the changing meaning of the law or how rights evolve. It was all a text-based argument about what those words mean. Their first year together, the previous year, they actually disagreed more than any 2 justices appointed by the same president serving in their first term in history. This term, they were a lot closer together. I think they were the pairing third most likely to agree. They still, you see that they have lively minds, that they approach seriously the text, structure, and history of the Constitution, pushing back on the administrative state. But you also see differences. So they're going to be serving probably for 30 years together, and not everybody, they're not going to please everybody all the time, but you do see kind of the vibrant intellectual thought, not just among appointees of Republican presidents, but both of them being appointed by this Trump administration.
As we get set for the return of the justices, what are some of the main things you're going to be looking at in the term ahead?
Well, there are about a dozen or 15 cases on the docket. The court's going to add a few more later this month before they resume, presumably, they haven't announced it, but presumably telephonic hearings again in October. A handful of really big cases, none of which are going to be ruled on before the election, certainly. But for example, whether Philadelphia can ban Catholic social services from participating in their foster and adoption programs because they won't place kids with gay couples. That's Fulton versus Philadelphia. Or Delaware is one of a number of states and other government bodies that designate by political party members of, in this case, their three highest state courts. So no one party affiliated person can or no party that has affiliations can be more than a bare majority of the state Supreme Court, for example, reserving all other seats to the other major political party. So that kind of affiliation restricted limits. Does it discriminate unconstitutionally against, say, libertarians or independents or socialists or what have you? That's the case of Carney versus Adams. Obamacare's individual mandate, whether it's constitutional, and if not, what of the rest of the law has to fall? Didn't we decide this 8 years ago? Well, yes, but in the intermediate time, Congress has changed, tweaked, zeroed out the John Roberts's tax penalty for not buying insurance. What consequence does that have? That's the case of California versus Texas. Very significant. And they're going to argue, they're going to add other controversial ones as well, I'm sure.
That is the voice of Ilya Shapiro. He is director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute and publisher of the Cato Supreme Court Review. And as we said at the beginning of the interview, author of a new book called Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court. Let's turn to the book, Supreme Disorder. Tell us what's on the plate if people pick this book up.
I appreciate that, and it officially comes out September 22nd, but available for pre-order on Amazon or wherever online you go to get your books. And I'll make this offer to your listeners, I should say, Mitch, that if anybody buys it, pre-order or otherwise, and sends me that proof of purchase, I'll be happy to mail them a signed book plate. We can't do in-person signings, but I'm happy to accommodate in that way. So what this book is about is this toxic atmosphere that our judicial nomination confirmation process is in. And indeed, the Supreme Court itself is part of the same kind of toxic cloud that our whole public discourse is in. Well, I looked at the history going back to the very beginning, going back to George Washington, and it turns out that politics has always played a role in judicial nominations, in the way the court is perceived, in its internal machinations. Now, what's changed is that we have the culmination of several trends where divergent interpretive theories of the Constitution, of statutory interpretation, map onto partisan preferences at a time when the parties are more ideologically sorted than they have been since at least the Civil War. It's actually unusual to have the more conservative members of the court all be appointed by Republicans and the more progressive members be appointed by Democrats. And so given that it's a zero-sum game, there's only a certain number of seats, both at the Supreme Court and the lower court level, and what the judiciary decides is really, really important. You're going to have these pitched battles. So the only long-term solution, I mean, I talk about various reform proposals, whether term limits or expanding the court or rebalancing it in various ways, changing the nature of confirmation hearings, all that, we can talk about it, but it's really rearranging deck chairs on the Titanic. And ultimately, the problem is with the product, not the process. And so only when we rebalance our constitutional order in terms of federalism, having more power in states and localities, separation of powers so that Congress is actually legislating rather than punting to the executive branch that can only be sued rather than outvoted or voted out rather. Only then will these judicial nominations become less important and therefore less fraught.
In putting together this book, did it give you any greater sense of why this current court operates the way that it does? I mean, going back and looking, seeing how these folks get to the bench and the tough road that people face. I mean, any of us who remember Clarence Thomas and his hearing, or more recently, Brett Kavanaugh, I mean, it's been a tough obstacle course just to get on the bench. Does this give you any more of a sense of why they rule the way they do once they get there.
Yeah, Don McGahn, President Trump's first White House counsel, who orchestrated the strategy for judicial nominations, including of Gorsuch and Kavanaugh, likened the confirmation hearing process to a Hollywood audition to then become a member of a monastery. It's really kind of an odd scenario. But this came about through a series of escalations, a ratcheting up of tensions that started long before Kavanaugh or Merrick Garland or Clarence Thomas or even Robert Bork. And that, I think, is the court's own self-corruption and Congress abandoning its duty to legislate, delegating more and more of its authority to the executive branch. Kind of all the branches are guilty in some respect. And so as the political dynamic has shifted, and as I said, the wars are over judicial philosophy rather than either cronies or geography or some other kinds of consideration that did not map on neatly to partisan divisions. This is what we're going to end up with.
The book, once again, is titled Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court. Its author is Ilya Shapiro. And if people buy the book and want to take advantage of your offer, how would they contact you?
Yeah, email me, ishapiro@cato.org. Just send me that proof of purchase and your mailing address, and I'll happy to sign you a book plate.
Ilya Shapiro is director of the Robert A. Levy Center for Constitutional Studies at the Libertarian Cato Institute and publisher of the Cato Supreme Court Review. Taking advantage of a brief break in the work of the Supreme Court, they'll be back in action very soon. We thank you so much for joining us on HeadLocke.
Thank you, Mitch. And in addition to my book, I should plug Cato's Constitution Day Conference, which anyone can view in this virtual age, September 17th, when we release the latest Cato Supreme Court Review. So thanks very much.